Yes.
Just to recapitulate, Mr.
No need.
No need.
We are just only one day away, Mr.
I
Chairman.
don't know, not. I'm not going to take. I only want to make one point.
I have only one submission in this, Malad. I filed an impleading application for the auto rickshaw unions, Malad.
For the
auto rickshaw drivers
Okay,
union.
okay.
Who want to oppose?
This is this side now.
Yes.
Fortunately, yesterday was more on my side. Now the side, that side, my lord, is getting populated a little more.
Yes.
Yesterday, my lord, I almost stopped at the point where I said
that if the statute is clear and the law has been declared by this court, there can't be a policy contrary to that. And then, Lord, I said that insofar as a rider is or an owner is concerned, he's entitled to register it as a transport vehicle
and get a contract carriage permit, both of which can't be denied unless there is a good enough reason which should be contained in the rules, which are made, my lord, by them. Now, if I satisfy all the requirements that are there in the rules for being granted a contract carriage permit, I should be granted it, unless there's some rule which says I should not be granted it. Now, the case of the state can't be that dehors the rules or dehors the act. I will now make a policy, and that policy will say I will not give permission to anybody to use it as a contract carriage. There, my lord, is where we stop. I want to start, my lord, my submission today, pointing out that the right to utilize my vehicle as a taxi or a transport vehicle is a fundamental right. And therefore, I have a fundamental right under Article 19(1)(g), which is recognized in two judgments. I'll place those judgments first before your lordships. Not Sagir Ahmed and Mithilesh Garg. I'll just pass it on. Lord has the first one, Lord, is a constitution bench judgment on under the old act when they were license Raj, and even then, whether to operate a vehicle as a transport vehicle was a fundamental right was a question. In Sagir Ahmed, give it.
Yes.
Para 12 on the 4th page. Let me come to the extract, a few lines before the extract at para 12. Under the Indian Constitution, it starts.
Yes.
My Lord's got Sagir Ahmed. I think my Lord Justice Joshi has Sagir Ahmed. Para 12. 5 lines before the extract.
Yes.
Under the Indian Constitution, the contract carriers as well as the common carriers would occupy the same position so far as the guaranteed right under Article 19(1)(g) is concerned. Both are liable to be controlled by appropriate regulations under clause 6 of that article. The law on the point as it stands at present has been thus summed by the learned judge. The true position then is that all public streets and roads vest in the state, but the state holds them as trustees on behalf of the public. The members of the public are entitled as beneficiaries to use them as a matter of right, and this right is limited only by the similar rights possessed by every other citizen to use the pathways. The state as trustees on behalf of the public is entitled to impose all such limitations on the character and extent of the user as may be requisite for protecting the rights of the public generally. But subject to such limitations, the right of a citizen to carry on business and transport vehicles on public pathways cannot be denied to him on the ground that the state owns the highways. Well, that argument is not advanced here as yet, because the roads are the state roads. That's the only argument which is not advanced, I must say.
Yes.
Para 13, we are in entire agreement with the statement of law made in these passages. Within the limits imposed by state regulations, any member of the public can ply motor vehicles on a public road to the extent he can carry on the business of transporting passengers with aid of vehicles. It is to this carrying on of the trade or business that the guarantee in Article 19(1)(g) is attracted, and the citizen can legitimately complain
if any legislation takes away or curtails that right any more than that is permissible under clause 6 of that article. Now, my lord, all reasonable restrictions are contained in the acts and the rules. And the act and the rules prescribe the entirety of what could be done. We have not challenged any of those, nor are we complaining against any of those. Our entire complaint is you are doing something outside it. If the law therefore permits it and therefore enables me, my lord, to exercise freedom of profession or freedom of business, then it is incumbent on the state to take every step to protect that right. The state cannot turn around and do something which will disable that right, which is exactly what's happening today. And that can't be done. Similar, my lord, after the 1988 Act, in the context of motor vehicles, in Mithilesh Garg, I think the other judgment which has been given to your lordship, para 5, my lord. Para 5, Parliament in its wisdom, I'm sorry, my lord's got. Parliament in its wisdom has completely effaced the above features. The scheme envisaged under 4757 of the old Act has been completely done away with the Act. The right of existing operators to file objections and the provision to impose limit on the number of permits have been taken away. There is no similar provision to that of section 47 and 57 under the Act. Statement of objects and reasons of the Act